Can you be arrested under the Custom Act? What is arrest and what is imprisonment? How are these two terms used in the Customs Act? If you want to know more, please stay tuned. My name is Viren Dayal. I'm a custom broker and a LSC certified trainer in customs law, applied rules and regulations.
For latest updates, subscribe to our channel and press the bell icon.
And the topic I've taken today is offences and prosecution under the Customs Act 1962. How are the offences different than the other penalties which we have discussed in the other topics? Offences and prosecution under the Custom Act invokes criminal liability, which is different from civil liability. The criminal liability will lead to arrest and imprisonment, which can be tried only in a sessions court by a sessions judge. Let us discuss what are offences and prosecution under the Customs Act and what are the underlying provisions. Chapter 16 talks about offences and prosecution under the Customs Act and covers section 132 to section 140. But how can I put a person straight away behind bars? Can I do so as a custom officer? No, I cannot do so even though I am a custom officer. And who can do it? So first you have to understand the concept of arrest, which is different from imprisonment. Under section 104, a person can be arrested in case there is an evasion of duty, and upon arrest will be taken to the magistrate, sessions judge, and will file a charge sheet that this person has done so and so criminal offense and should be given a imprisonment, should not be bailable, should be a cognizable offense, and so on. So now let us understand the difference between arrest and imprisonment. So a custom officer can arrest a person, that means temporarily restraining him from movement because he has committed an offense under the Customs Act 1962. So a custom officer can temporarily restrain you and seek custody under the Customs Act but cannot imprison you. The power of imprisonment only lies with the sessions judge or a magistrate who can imprison a accused and put him in jail. Therefore, the custom officer has got a limited role of only arresting a person and not imprisoning him. So the role of the custom officer ends once he has been arrested and taken to the magistrate, who will further decide whether it should be bailable or non-bailable and whether the person is liable to be imprisoned or not. So these are the basic fundamentals of arrest and imprisonment which are enshrined under section 104. Let us now analyze the provisions of chapter 16 which talks about offences and prosecution. The first section is section 132 which talks about false declaration. Where any false declaration has been given or false documents have been submitted while transacting business in a custom house, that means mainly for imports and exports. In that case, where knowingly, that means you already have a guilty mind or mens rea, that is culpable state of mind, and you have changed the documents so as to evade duty or any other reason, then you will be imprisoned either for a period of 2 years or with fine or with both. These are the basic features of section 132. Section 133 talks about obstruction to a custom officer. What does obstruction mean? Obstruction under the provision of the Customs Act could mean that when a custom officer approaches you, maybe you threaten him or you try to induce him with some favors either to him directly or indirectly. Or seeing a custom officer approaching you, you run away, that is also a part of obstruction. You do not cooperate with the proceedings is a part of obstruction. Please remember that the custom officer is doing a sovereign function under the Customs Act on behalf of the President of India and has reason to believe that there is an omission of something which is liable for confiscation, and therefore the custom officer is doing work in good faith and therefore cannot be said no when he comes to or he approaches someone under the provision of the Customs Act. Therefore, obstructions are of many types as discussed here, and the person who obstructs the officer of customs while doing his duty can be imprisoned for a period up to 6 months or with fine or with both. The next section, section 134, pertains to refusal of being x-rayed, and this can lead to contempt of court. Now coming back to section 103, the proper officer has got reason to believe that this particular person must be x-rayed because there's something hidden in his body, and the custom officer takes the person to the magistrate and magistrate gives order that so and so must be x-rayed to find out whether there's anything liable to confiscation which is inside the body of the person. In such a case, if the person does not cooperate with the custom authorities to be x-rayed, it will be deemed to be contempt of court. The person can be imprisoned for a period of 6 months, or with fine, or with both. And this section, as I've termed it as the nucleus or the important section of this particular chapter, is evasion of duty of more than 50 lakhs, or the value of the goods are more than 1 crore, or fraudulently claiming any exemption of the Custom Act of more than 50 lakhs, or fraudulently obtaining any drawback of more than 50 lakhs, or fraudulently using any instrument in the clearance of the goods, and the instrument has been issued by the DGFT, that is under the foreign trade policy. In such matters, a person can be arrested without a bail, and also it will be termed as a cognizable offense. That means no arrest warrant is required. So under section 135, the term of imprisonment is up to 7 years and with fine, not or with fine. But in some circumstances, the magistrate has got the power, for reasons to be recorded in writing, to reduce the term of imprisonment up to 1 year, and accordingly order the accused to be imprisoned. However, when the magistrate has to imprison a person up to 1 year, then has to consider the adequate and special reason which the magistrate has to state in his order, that why he is giving an imprisonment to 1 year. But what are the special adequate reasons which the magistrate cannot consider are the age of the accused, the fact that the accused is not an offender in the past, the fact that the accused has paid all the penalties, fines, civil liabilities has been completely been paid by him. Therefore, these reasons are not deemed to be adequate and special reason to give an imprisonment of less than 7 years to the accused. These are broadly the features of section 135, and they have a lot of bearing on the chapter as well as on the fate of the accused, because it leads to imprisonment and with fine. Interestingly, section 136 under the Custom Act penalizes the custom officer with imprisonment up to 3 years or with fine or with both when a custom officer either abets to do something which is not supposed to be done under the Custom Act or any other law for the time in force, or some goods which are prohibited are allowed to be imported or exported, or circumstances lead to a fact that certain duties are collected less in India, and in such cases a custom officer can be imprisoned for time up to 3 years or with fine or with both. However, custom officer will not be imprisoned or fined in case he is discharging his duty and discloses the information in the normal course of business or in good faith under the provision of section 155. There is one more interesting part in section 136, where a custom officer can be imprisoned up to a period of 6 months and with fine or both. This section is subsection 2 of section 136, where the custom officer, without having a reason to believe, can be imprisoned up to a period of 6 months or with fine or with both. This is known as vexatious search, and in such cases the penal provisions are attracted and the custom officer can be arrested as well as put behind bars. Another interesting section in this particular chapter, section 137, that is known as taking cognizance of offense. That means the court taking notice of the offense and starting the proceedings, and compounding of offenses, that is allowing the accused to start on a clean slate by considering the compounding amount which is to be paid by the accused, and where the proceedings in a court of law have either commenced or not commenced, and the court is satisfied that the compounding amount has been paid by the accused to the compounding authority under section 137. Here the compounding authority is the chief commissioner or the principal commissioner of customs, and upon the payment, and if the court agrees, then the case is either withdrawn, or if it is not commenced, it is deemed to be cancelled. This is known as compounding, and the importer can then start on a clean slate. For this, compounding of offences rules 2005 have been made by Indian Customs. The last section in this topic, section 140, pertains to offences by companies. As you are aware, company is an artificial person and is run by the board of directors, the managers, and so on. In such circumstances, how do you arrest a person under this particular chapter? So section 140 is broken up into two parts, subsection 1 and subsection 2. Under the provisions of subsection 1 of section 140, the accused, let us say the manager, managing director, has to prove That means the onus, the burden to prove that he is not guilty is the person who has been accused, and he has to prove that it was done without his connivance, it was done without his knowledge, and that he had taken adequate steps to see that the offense is not committed. But still it was committed. But he is not guilty, it was not done with his knowledge, or he had taken all possible steps so that the offense is not committed. So the burden of proof is on the person accused to prove himself not to be guilty. But in subsection 2, the onus to prove that a particular person is guilty of an offense is on the prosecution, that is the Customs Department, to prove that so and so is guilty and that he carried out this act which led to an offense by the company. So in subsection 1 and subsection 2, there are two important points which leads us to conclude in this particular case that in subsection 1 the onus is on the accused, and in subsection 2 the onus is on the department. Which are those 2 points which are there which differentiates these 2 points? Let us see that now in this concluding. The two differentiating points under subsection 1 and subsection 2 are that in subsection 1 the accused has to prove, if he proves that, and in subsection 2 if it is proved that. If he proves that means the accused has to prove he is not guilty, and in subsection 2 if it is proved means the department has to prove that this particular person is guilty. So this is the topic of offenses under section 140, and here I conclude the chapter 16 on prosecutions and offenses under the Customs Act.
For detailed learning of all logistics subjects, visit www.logiveda.com.